time period within which you have to do that. Having said this, yes, litigation is kind of emerging in patents in India now. But over the last, maybe, I think that the point when patent litigation really took off in India was in 2005, when the Indian law was amended. We started getting in patent protection for pharmaceuticals. And maybe that was really the takeoff point. And besides that kind of change in terms of subject matter protection, there has really not been any substantive change which would have prevented otherwise patent holders from other areas of technology from enforcing patent. So really to that extent, nothing much has changed, except that we did not have so much of patent litigation earlier in any area of technology. 2005 was the starting point when litigation really started to begin. Over the last, maybe I would say 2005 to 2012, there was a very high point in patent litigation in India, solely focused on pharmaceuticals. So it was multiple forums that we started looking at, right from the patent office, the High Court, the appeal court having been set up because of the Novartis-Glivec case. That came into being in 2007. Then you had the opposition proceedings, pre, post. So several opportunities, several points at which you can do an invalidity attack on patents, leave not only pharmaceuticals but everything else. And that was put to rest by the Supreme Court decision. And I'm sure everybody knows about that order. That's the Enercon, the famous Enercon order, where kind of it put a rest to everybody's, at least patent holders' worries that you're entitled to challenge a patent at all stages because the law provides you or entitles you to challenge that patent, be it at a pre-grant stage, post-grant, revocation, a counterclaim. So that was the high point of 2014, I would say, the Supreme Court order in the Novartis, in the Enercon decision. But I think what really gets unnoticed is what's been happening in the telecom sector. So this is one of the reasons why I really decided to, as I said, nothing really changed in the statute or the law, nothing so significantly changed in the statute or law that would have prevented patent holders in the telecom sector or in the software industry to protect or defend their patents. But maybe it's been only in 2013 onwards that there have been the telecom patent wars. It's like the Apple and Samsung war that was that's been happening globally, but in India it's at much smaller level, but with the Indian domestic telecom manufacturers. So with that, maybe I'll just begin with, I'll be happy to address pharmaceutical, but Dr. Diwan is here, and I can certainly take pharmaceutical questions, not that I'm saying that I will not address if there are any concerns, but I'm kind of focusing my presentation today on the telecom. Why fight now? As I said, we always had that legislation. Protection was always being granted to telecom patents. We've always had the concept of standard essential patents. We've had all kinds of protections have been available. So why is it that it's been only in 2013 and 2014 that the patent war in the telecom sector really began to take off? And I did a very quick analysis, or maybe just to find out what could potentially be the reasons. Is it something to do just with the patent law? Or is it something to do with just the judiciary, the way they've been operating, or the kind of orders that patent holders are expecting from the judiciary? Or is it a mixed bag of the government policies and the statute and the judiciary? So it's the executive, legislative, and also the government policies. So what emerged of the short research that I did was that the telecom market is huge in India. It's very, very huge. And as per the TRAI guidelines, the overall teledensity has increased to 74.55% in 2014. What this means is that if we just take an example of mobile handsets, So 74, in any particular area, at least 74.5% of the population would be using one or the other kind of, a mobile handset. Maybe the confidence, the second reason which I could attribute is a stronger patent regime post-2005. It's always been there, as I said. Nothing much has changed, but I think it's more to do with the trust in the judiciary that we've seen over the years in the pharmaceutical sector, and that's kind of spilled over to the telecom sector. So that's brought in some kind of faith and belief in the patent holders that yes, India is just right now for enforcing patents in the area of telecom, which is kind of unlike the pharmaceutical. I wouldn't compare it to a trademark infringement action, but if it's something to do with new chemical entity, it's either there or not there. You can visually kind of see it if it's a chemical structure. If it's a replicate of a chemical structure, it's an infringement. If it's not a replicate of a chemical structure, maybe that's when it's highly contested. It's contested even when it's a chemical structure. But then it's easier to kind of go ahead with those kind of infringement actions. Whereas in telecom, I mean, you pick up any handset, you would not even know which patent number is in that. So you could have 100 patents that go into one handset. And that's one of the reasons. What would the reaction of the courts be in India? How would they perceive such kind of infringement actions? What is the kind of evidence that you have to lead in a patent infringement action in the area of not just telecom, maybe e-commerce or software or any kind of non-pharmaceutical related inventions? There were also policy reforms post-2005. There was, an increase of the foreign direct investment in the telecom area from 49 to 74%, almost double. And obviously the launch of latest technologies and products such as 3G and WCDMA technologies in the market. And maybe this was one of the reasons that the biggest plaintiff, I would say, or the patent holder that has been enforcing the patents in all forums has been Ericsson, because they are the largest holders for standard essential patents. Cheaper handsets, highly competitive market. So you have large volume sales in India. Large volume sales, smaller manufacturers, not very big defendants, and a highly competitive market where you could get a handset anything between, say, 1,000 rupees to a few 100,000 rupees. Before I come into what the patent infringement scenario looks like in India in the area of telecom, it's good to kind of at least have a bird's eye view of what the trends, patent trends have been in India. Unfortunately, there have really not been any, or maybe they are negligible, not that they came up in my analysis. There have been very, very few patent filings in the area of telecom by Indian companies. So be it Micromax, Kinstec, or any other Indian company, they haven't been really filing patents. And they're solely relying on these standard essential patents or other patents being licensed from like Ericsson, Qualcomm, not so much RIM, Research in Motion, which is now BlackBerry, Motorola, and Nokia. So if you look at this graph, there has 2012 and 2013, and this could possibly be the reason. Qualcomm is one of the largest filers in the telecom area. And not that they manufacture handsets, not that I'm aware of, but maybe the chips that go into these mobile handsets. But the other companies are Korea. Obviously, you have Samsung and LG from Korea, and then Ericsson is actually a very, very big player, and BlackBerry, Motorola, and Nokia. So this just gives you this gives a flavor of what the landscape of telecom is in India. And maybe with this kind of patent litigation, we might just see a lot more of invalidity actions before not just the high courts, but also before patent offices and the appeal courts, which is the IPAB. Now, before dealing with the position in India and what are the kind of cases that have really emerged in the last 2 years, I did talk about the NERCON decision. Interestingly, what's happening, at least in the automobile sector, and I'm sure everybody must have read about that, is that people are taking recourse to the CCI, which is the Competition Commission of India, something akin to the antitrust law in the US or the FTC in the US, and they have started kind of registering complaints with the CCI as more in the nature of abuse of dominant positions. So that's interesting, which has now emerged more in the non-pharmaceutical. This is a forum that has emerged in the non-pharmaceutical side, and there have been, there've been whispers of companies or defendants taking even pharmaceutical companies to the CCI where there are settlements that have been happening. Now, CCI obviously is it has a lot of role to play in the telecom infringement actions or the telecom litigation practice. And the other forum, in addition to the Patent Office or the High Courts or the Intellectual Property Appellate Board, is also the customs. Because we did have this custom border intellectual property right rules, enforcement rules of 2007, which allows all patent holders to register their patents with the custom authorities. And there's a procedure that you have to really follow where any import of patented or infringing goods into the country can be stopped at the customs just merely by registering your patent there. I've known of telecom, obviously, a lot of patents have been registered with the customs in the telecom sector, but nevertheless, there have been registrations also for, I would say, agrochemicals. I'm not going to name the company, but there are companies in the area of agrochemicals that have been registering their patents with the custom authorities. But again, multiple dispute resolution authorities. So as I said, you could have a patent assertion defense with any of the jurisdictions. And this is essentially what, was possible maybe prior to June 2014. But after the NERCON decision, leaving apart the customs and the CCI, you could initiate an invalidity action right at the Patent Office, the IPAB, or even at the High Court. So what was the impact of the NERCON decision? This is the Dr. Alois Warburton case. It's known as the, colloquially it's known as the NERCON decision because Dr. Alois Warburton is the chairman of the NERCON, one of the largest German companies in the wind technology. So what did the Supreme Court say? The Supreme Court said that if there is an infringement suit filed, invalidity challenge, infringement suit before the High Court, you cannot institute an infringement suit lower than a district court. So if there is an infringement action, it's typically before a district court or a High Court, but if you have an invalidity challenge that accompanies the infringement suit, and if the suit has been filed with the district court, it goes to the High Court. There's an automatic movement from the district court. The Supreme Court said that if there is an infringement suit, the invalidity challenge shall be heard by a superior forum only. And if the validity has been challenged at the Patent Office or the IPAB apart from the High Court, then only the counterclaim will lie. So let me give you an example. So if you have an infringement action that's been filed prior in time and there is no revocation action before the IPAB, the defendants cannot then go back to the appeal court and file a revocation. They have to necessarily go to the High Court in a counterclaim. Whereas if there is a revocation that precedes the infringement action, the defendants can only pursue the counterclaim. They cannot have an invalidity challenge in the High Court action through a counterclaim. Interestingly, there were two additional issues that were discussed in the Supreme Court order, which were the obiter of the order, and those were obviously crystallization of the grant of the patent. And I think the Supreme Court went ahead and said that the rights of a patentee do not crystallize in the event there is a post-grant opposition that's been pending. So you have to really wait for that 1 year window period after which a post-grant window will close, and that's when it materializes. Quite a departure from the Delhi High Court order in the, I think it was the Snelata decision, if I remember correctly. That's also been like 2009 order, when the Delhi High Court said that that when you are looking at when the date of grant is going to be the date on which the controller orders the grant of the patent. So you really don't have to wait for the seal to happen or a post-grant publication to happen. Quite to the contrary, Supreme Court kind of went back and said, no, you have to wait for the publication as well to happen, because if the publication doesn't happen, it really hasn't materialized. Your patent right hasn't really materialized. That's the ultimate final seal for a patent to be enforced. Now coming to the telecom litigation, this was in 2010, where Tenexi, a wireless communication company, it was a Canadian company this was the first litigation that happened, and this is still at trial, but at least at the preliminary issue, the Delhi High Court ruled that the grant of patent should include specific findings related to novelty and non-obviousness, and more a side issue, they said the international search report and the examining written opinion of the examining authority are not binding on the patent office. This was also a unique case to the extent that there was some kind of discussion on the disclosure requirements that we have in India, to the extent that there was a non-disclosure of a Canadian application. So Tenexi did not give the patent office that information, which led to the refusal of a preliminary injunction to Tenexi. Now this case is at trial. There are no cases so far that have really gone to full trial as of now. Just an overview of the standard essential patent cases that are currently pending with the several forums. So we have the custom recordal customs, you have a patent registers its patent with the authorities, and some of these patentees include Ericsson, Ringo, Ram Kumar, and the infamous Ram Kumar, and Bharat Bhogilal Patel. They've dealt it, I'm not going to go into the details, because if I go into a case study, maybe it'll take me a few hours to talk about it. But in the Delhi High Court, Ericsson, if you see, Ericsson and Ringo have actually been in the forefront.